It's the Law with Morelli Churtko. Joining us on this edition is Scott Hugabart, whose area of expertise in the law that he practices, business law, real estate, will estate planning, powers of attorney, and representation agreements is what we're going to be talking about today. Scott, first of all, let's discuss what is power of attorney.
Thanks, Howie. At its simplest, a power of attorney is a document that a client would sign that would appoint a person who's called their attorney, and that document would allow the person appointed to do effectively anything with respect to the client's financial affairs that the client could do for themselves.
Okay, so why would a person need one?
Most people make one against the possibility that something happens to them where they don't die, so their will's not helpful, but where they lose capacity. And so they're unable to pay their bills and sell their car if they can't drive it anymore, or remortgage their house or sell their house. And that's what they're looking to do, is to appoint someone who can assist them with some of those things that they're not able to do anymore.
So let's move on to a representative agreement. What's that?
The simplest way to think about it is the same kind of thing as a power of attorney, but for making healthcare decisions. Many people think of that in terms of end-of-life decisions, but it's a lot more than that. It's about advocating for someone while they are alive. What kind of medical care do they get? What kind of medical care do they not get? What kind of drugs are they prescribed or not prescribed?
So why would a person make a representation agreement?
Really for the same reasons as making a power of attorney, where there is a possibility that at some point in the future they may lose capacity and not have the ability to make those decisions for themselves. In that case, they would want to appoint someone who would make decisions consistent with how they would make them for themselves. These are particularly useful in families where there are subsequent marriages and children from previous marriages, where there might be disagreement about what kinds of care an adult might receive or not. This allows the person who makes the power of attorney to decide who's going to make those decisions so that they can choose the person who they think would make them on the most consistent basis.
Can these powers be abused by the person that you appoint?
Of course they can, and the topic of elder abuse is becoming more prominent in our society. There are some rules within the Power of Attorney Act, for example, that prohibit the person who's appointed as a power of attorney from transferring assets to themselves, from transferring assets that are designated to beneficiaries in a will. The legislation requires that the person who's appointed as a power of attorney keep records, but that doesn't always happen. And if a person becomes aware that there is abuse of a power of attorney in particular, one of the things that they should do is contact the offices of the public guardian and trustee. They have a role in protecting vulnerable individuals, and it's really important for all of us to keep an eye for these things.
When families go through this kind of thing, I imagine the more rules and regulations, and if you get people involved such as yourself, I imagine things run a lot more smoothly. Really,
to have a discussion with a lawyer when you're thinking about making a power of attorney and or a representation agreement is pretty important. I mean, we'll canvass, all of those questions about safeguards in your family, and are you appointing one person or more than one person? Can those people get along? Is the person that you're going to appoint likely to keep your family informed? Because that's an important thing. Most of us, when we don't get information, tend to fill that vacuum with sometimes the worst possible thoughts. I think, just to come back to powers of attorney for one moment, sometimes people will think, just to use a house as an example, I don't need to worry about a power of attorney because the house is in both my name and my wife's name. And that's the very situation that we actually need a power of attorney. If something were to happen to me and my wife were to look at the house and say, I can't manage all these stairs, I'd like to sell this house and buy something that's flatter. What she'll find out is that because the house is in both of our names, she can't sell it because I'm not able to sign. And that's what a power of attorney is for.
Scott Hugabart from Morelli Churtko on this edition of It's the Law.